Hey kids, 5 minutes to a better test score on your 2022 last test of the year, judicial branch. First, we start with the Miranda Rights. There are 5 lines to this. You need to know all 5 lines. The first is this X, you have the right to remain silent. Second line is anything you say can and will be used against you in a court of law. Third line is you have the right to an attorney. Fourth line is if you cannot afford one, one will be provided to you. And the fifth line is do you understand these rights? The 13 steps to a criminal case, easy. I taught you the mnemonic device. Aunt Betty picked grapes in Allegheny, Pennsylvania. She offered warm cans, very sweet. Here's what each of those letters stands for. Aunt is for arrest. B is for booking. P is for preliminary hearing. G is for grand jury hearing. I, indictment. Allegheny, arraignment. P in Pennsylvania is for pretrial motions. S is for selection of petit jury, and she offered is for opening statement. W is for witness testimonies. Cans is for closing statement. Very is for verdict, and sweet is for sentencing. If you remember this acronym, you should be able to get that correct easily. Lastly, the cases, the Supreme Court cases, there's 8 of them that you need to know. I'm timing myself so I can get through all 3 of these really quick. The key is to know the legal standard or the line. I call it the one-liner sometimes from each case. This will be helpful for the matchup. Then you need to pick one of these major cases and tell the whole story. So if we come across that one, you might pause this video quick and then write everything down and practice it. There's a thought. All right, we'll start with Marbury versus Madison. In this story, it was about 1800 in Washington, D.C. Adams lost the election to Thomas Jefferson. And as Adams was trying to remain in power, he passed all these judges really quickly into power. We call them midnight judges, and they were Federalist. They wanted to do that to try to block Thomas Jefferson's laws from going into office. He ran out of time, though, and this man, William Marbury, did not get his appointment. He sued, took it to court, and he lost. This is because the Supreme Court did not have the power to give him that job. It was unconstitutional. Therefore, it established judicial review. In Plessy versus Ferguson, it was about 1896 in Louisiana. Homer Plessy sits in this white train car instead of his black train car. He gets arrested for it. He sues for equal protection under the law, and he fails. This is because the legal standard of separate but equal facilities was available. Therefore, it was legal, even though it was not fair. Brown versus Board, real quick. 1950s in Kansas, Linda Brown had to walk 20 blocks to go to an all-black school when she lived about 5 blocks away from a white school. Dad sued for that inequality, and he wins. In a 9-0 decision, the Supreme Court said that separate but equal facilities is unconstitutional, and this is how it is today, boys and girls. Gideon versus Wainwright. In 1960s in Florida, this man Gideon was convicted of a crime he did not do for breaking and entering into a pool hall. He asked for a lawyer because he couldn't afford one. The judge denied it because he wasn't up for the death penalty, and he was sent to jail. He lost. He was at a disadvantage without an attorney. In a 9-0 decision, the court overturned that ruling, gave him a new trial where he had a lawyer, and he earned his freedom. What's the legal standard? All people are guaranteed the right to a lawyer if they can't afford one. In Miranda versus Arizona, this is the Miranda Rights case in the 1960s in Arizona. This man, Ernesto Miranda, was convicted of kidnapping and raping a woman. He was arrested. The police officers forgot to say 2 things. You have the right to remain silent, and you have the right to an attorney. In a 5-4 really close decision, the SC ruled that Miranda's rights were violated. He was retried, still found guilty, but it proved that everybody has a right to an attorney if you can't afford one, and you have the right to remain silent. In New Jersey versus TLO in 1980s, in New Jersey, 2 females were caught smoking in a bathroom by a female teacher. They were told to empty their purse, TLO was, and they found pot, list of buyers, and some money. TLO says, hey, that violates my 4th Amendment rights. No, it did not. And that is because in a 6-3 decision, the Supreme Court said, guess what? We can search your stuff if there's probable cause or reasonable suspicion. In Tinker versus Des Moines in the 1960s in Iowa, these kids wore a black armband to protest the Vietnam War. It was labeled a disruption. They were suspended. In a 7-2 decision, the parents and the kids won. Their rights do not stop at the school door. Free speech does not stop at the school door. It was legal. My last one, Roe versus Wade, is about abortion. A woman tried to get an abortion in Texas and she sued for that under the right of privacy. 7-2 decision. It was ruled that under a woman's zone of privacy laws, abortions are legal if they are in the first trimester